Have introduce Derrick Strahorn, who will be talking to us about contract law, because as you do buying and selling properties, you actually deal with contracts. So welcome, Derrick.
Good evening.
Good evening.
So let me give you a quick bio for those of you who don't know me. Been in GD RIA now for more years than I can remember. But started my career at LexisNexis, as probably a lot of lawyers in this town have done. It's still not working. It's been one of years. Better? Same.
Yeah, that one.
Can you hear me now?
Didn't give it away.
I think that's it.
I'll just speak up. I'll just scream. Okay, so began my career at LexisNexis, was there for about 8.5 years, decided I didn't want to be in corporate America anymore, so left about actually 21 years ago this month and started my own law practice. So I've been practicing law ever since. General practice, so we do criminal work, civil work, a lot of different things, family law, which includes divorces and child custody and child support, probate matters, but also focus a lot on real estate and landlord-tenant matters. So I was asked to talk to you tonight about contract law, which is, if you ask any law student, will tell you is an infinitely boring subject. But what I'm going to do is try and talk about it in the context of what we do. And I say we because I'm also a real estate investor as well as having my own law practice. So many of the things that I've encountered are similar to things I'm sure you've encountered. And so I have sort of this legal side of understanding these issues, but also from a practical standpoint of being in the shoes of many of you who deal with tenants and other issues on a day-to-day basis. So I'll try and make this as relevant to what you guys do as I can. While I'm talking, if you have any questions, feel free to ask. Just you can raise your hand and interrupt, and we'll try and deal with your questions. I want to try and make this as relevant for you as possible versus me just sitting up here talking. Because you know what happens when you just give a lawyer an hour and just say they can talk. So, and I'm going to put on my glasses so I can see when you raise your hand. First thing we're going to talk about are some of the myths I think that a lot of people encounter when we're talking about contract law. And I think one of the biggest myths that I run across in dealing with clients is thinking that if you don't have something in writing, you don't have a valid contract. And that is a total myth. The law in Ohio allows for you to have oral contracts. So you can have an oral lease agreement, which is a type of contract. So you can have an oral lease with a tenant. You can hire someone to do work on one of your properties, and you can hire them with an oral agreement. It doesn't have to be in writing. It's still valid. So you don't want to think just because you haven't sat down and actually signed something that you don't have a valid binding agreement. What the law is going to look to is see, have you met the elements or requirements for a contract? So has there been a meeting of the minds? Has there been an agreement for services or good in exchange for consideration? In other words, are you paying something for the goods or services that you receive? Does the person who you're entering into the agreement have authority or capacity to enter into a contract? For example, let's say you hire Bob to come and work on your property. Bob is doing some work. You run into something unexpected, as we all know happens often. Bob's not there, but Bob